Proceedings are resumed.
The Companies Amendment Number 2 Bill 2016.
Recognize Honorable Minister for Financial Services.
Thank you, Madam Speaker. I beg to move the second reading of a bill shortly entitled the Companies Amendment Number 2 Bill 2016.
The motion has been duly moved. Does the Honorable Minister wish to speak to the bill?
Yes, thank you, Madam Speaker. Madam Speaker, I think just for clarity, members may have the bill which shows just the Companies Amendment Bill 2016, but it was changed by an errata to reflect number 2 since there was a previous bill, Companies Amendment Bill in 2016. So, Madam Speaker, I have the pleasure of presenting this bill this afternoon on behalf of the government, which it's a bill which seeks to amend the Companies Law 2016 revision in order to require companies incorporated in the islands to establish and maintain beneficial ownership registers which may be searched by a local competent authority. Madam Speaker, while local service providers, have maintained beneficial ownership information on their clients for the last 15 years, international developments have steadily moved forward towards an enhanced approach to information sharing for beneficial ownership information. Although a new beneficial ownership information sharing initiative is currently being worked on by the OECD, the UK has positioned itself effectively since 2013 as a leader in the area of beneficial ownership transparency. That initiative on their part has resulted in all of the Crown dependencies and overseas territories having signed an agreement with the United Kingdom in April of last year to introduce a new beneficial ownership information exchange mechanism with the UK. Madam Speaker, in our case, we have determined that rather than having a central register, as the UK was pushing for, we would go with a similarly effective system, which is also contemplated in the FATF recommendations in respect of beneficial ownership information. So we will introduce a technology-based solution that builds on the strength of our current framework. This approach is referred to as a centralized platform, and it allows beneficial ownership information to continue to be maintained by local corporate service providers on behalf of their clients, but in an electronic format that is easily accessible from a central node. In other words, Madam Speaker, beneficial ownership information will continue to be disaggregated. That is, it will be maintained by the corporate service providers as it is now, as it has been for the last 15 years. But it can be searched by a government authority without having to ask the service providers to collate and provide the necessary information held in their systems, and it can be searched without their knowledge. Madam Speaker, the last point is critically important in that we must have a system which avoids a situation where the potential target of the investigation ends up getting tipped off. So this approach, Madam Speaker, builds on the fact that in our current framework, this information is collected by our service providers, but very importantly as well, is verified by those service providers. That is, Madam Speaker, one of the key distinctions between the system that the Cayman Islands has operated for the past 15 years and the system which the UK have implemented with their central register, which is effectively an honor system. The companies have to file with Companies House the beneficial ownership information, but nobody is checking it. Nobody is verifying it. Madam Speaker, as the data is disaggregated, combined with the fact that we will have a system which has a comprehensive level of security measures, we feel comfortable that the potential for the system being compromised will be significantly diminished or eliminated. To those critics, Madam Speaker, who will continue to argue that information sharing and transparency are not warranted and are a detriment to our local industry, I think they are ignoring the reality and they're woefully behind the times. Madam Speaker, a casual read of international media relating to transparency issues and beneficial ownership in particular will clearly show the importance of the issue of transparency globally, although there may be different approaches being taken in respect of it, particularly on the issue of whether it's public versus, or publicly available versus only available to the authorities, as we say should be the case. Madam Speaker, Cayman's success as an international financial center will not continue if we do not take the responsible approach of meeting international standards when they are international standards. That's not to say that we lead the way on initiatives. Not every initiative becomes widely adopted. And on the issue of whether there is automatic sharing, on the issue of whether there is access by the public, the Cayman Islands will not be leading on that issue, but we will have to adopt standards like that if they become global standards, if they are adopted by all of the major economies and our competitors. Madam Speaker, the government has taken a very prudent approach in respect of this matter, and we have been extremely measured in our efforts to improve the strengths of our jurisdiction, improve the system that we have in terms of collaborating or sharing of information and collaborating with international law enforcement authorities. In this case, only the United Kingdom at this point, because we certainly do not want, and we recognize that we must protect this jurisdiction from abuse from those who might seek to carry out illegal activities. When it comes to things like corruption, we need to be a part of the solution, not a part of the problem. And there is no client in this jurisdiction who is here doing legitimate business who is going to be concerned about that sort of approach, Madam Speaker. Madam Speaker, I feel very strongly that once completed, our approach will be a model for other jurisdictions to emulate, as it will effectively meet international standards by combining the strengths of our different traditional approaches to collecting, verifying, and maintaining beneficial ownership information. Madam Speaker, although this bill is primarily related to our financial services industry, it does also impact companies which are used to conduct local business. This is necessary, Madam Speaker, so as to ensure that our jurisdiction remains in compliance with the FATF, or Financial Action Task Force, recommendations for the combating of money laundering and terrorist financing. Wherever there may be a perceived or identified gap, Madam Speaker, the standards will require that we address that to ensure that it is not abused in some way. And we know, Madam Speaker, that by their very nature, anyone who seeks to do wrong will exploit areas of weakness. And that is the type of thing we need to guard against, because our reputation as a strong, quality jurisdiction which has a tremendous presence in the international financial services market, a global significant presence, is one that requires us to protect our reputation and ensure that we maintain our credibility, because that is the only thing that is going to ensure that clients see us as, continue to see us as that quality jurisdiction that they will come back to time and again. Madam Speaker, the key impacts on local companies are as follows. While exempted companies will be required to maintain their beneficial ownership registers with a corporate service provider, or what we would typically refer to as a registered office provider, local businesses will be permitted to continue to file the beneficial ownership information directly with the registrar of companies. They therefore will not be required to retain the services of a corporate service provider. Madam Speaker, at the moment, effectively, local companies provide ownership information, legal ownership information, in respect of local companies on an annual basis to the registrar of companies. So this just takes it a little bit further in terms of providing the beneficial ownership information. They will be required to identify those beneficial owners and file that separately with the registrar. Now, in the vast majority of cases, probably something in the 90% range, I would imagine, the information is likely, the information relating to legal ownership of shares in the local companies and the information relating to beneficial ownership in the local companies is likely to be exactly the same. I think we can be fairly sure that in the vast majority of cases, the beneficial owners are the same as the legal owners and directors of the business. If the beneficial owners differ, some additional information is required to be submitted. So, for example, an ordinary resident company conducting local business, which is owned in whole or in part by another company, they will have to identify the individuals who ultimately owns and controls the company, along with that shareholder. And one of the main changes introduced by the bill, Madam Speaker, will be a requirement to not just update that information on an annual basis in respect of the beneficial ownership. Sorry, let me back up. There is an existing requirement, for clarity, an existing requirement that the legal ownership of a local company is filed with the annual return. So it's done once a year. The new requirement will be in respect of the beneficial ownership information, that if there is a change at any point in time with that beneficial ownership information, they need to, within 1 month of that change, file the information or the update in respect of that with the registrar. Madam Speaker, I would again take the opportunity to re-emphasize that this government's position, this government's very firm position, is that beneficial ownership information of the clients of our jurisdiction will not be publicly available until such time as the rest of the world agrees to and implements a public register approach. We will defend the right to privacy, which is enshrined in our Constitution. In fact, Madam Speaker, in relation to the European Union, despite the calls made by some of its politicians, media, and even NGOs, even they recognize now that public registers would constitute an unreasonable infringement of privacy rights. So we feel very strongly that legitimate clients have a legitimate expectation of privacy in relation to this information. And that is only qualified, Madam Speaker, to the extent that there is a reasonable investigation by law enforcement authorities in relation to things like corruption, serious fraud, and other serious crimes. Madam Speaker, with this background in mind, the bill is arranged into 5 clauses. Clause 1 provides for the short title and commencement. Clause 2 amends the principal law by the insertion of a new part Roman 17a, which I will describe shortly. Clause 3 renumbers sections 244 and 245 of the principal law to adjust for the new part Roman 17a. Clause 4 inserts Schedule 6 into the principal law. This schedule lists the countries or territories that have entered into specific agreements with the Cayman Islands for the sharing of beneficial ownership information through the proposed centralized platform. I hasten to add, Madam Speaker, that at the moment, as I have said earlier, this list of countries is limited to the United Kingdom, given the exchange of notes and the technical protocol that was signed in April of last year. But certainly, it is possible that at some point other countries may be interested in sharing this information on the same basis and on the same terms and subject to the same limitations as the United Kingdom, as we have agreed with the United Kingdom in this approach. Clause 5, Madam Speaker, deals with the transitional provisions that no prosecution may be commenced against the company for an offense under Section 275 as enacted by Clause 2 of this law, unless the act or omission that constitutes or constituted the offense took place at least 1 year after the coming into force of that section. This is necessary, Madam Speaker, to allow sufficient time for Cayman companies and service providers to take the necessary actions to bring them into compliance with this law. Now, Madam Speaker, turning to the new part 17A, this part is organized as follows, Madam Speaker. There is a preliminary section which includes definitions, the application of the part, and specifications of the beneficial ownership information competent authority. Then we have section dealing with identifying beneficial owners, relevant legal entities, and registrable persons. This includes provisions that specify the duty of a company to identify beneficial owners having significant control over them, represented by holding directly or indirectly more than 25% of the issued shares, voting rights, or control in that, or other control in that company, and any intermediate legal entity through which such beneficial owner holds his or her interest in that company. Also, the duty of the company to give notice to such persons, the duty of beneficial owners and relevant legal entities to supply information, and the duty of the company to identify and register registrable beneficial owners on the beneficial ownership register. And to be clear again, Madam Speaker, when we talk about register in this respect, we are not talking about a register which is an aggregation of beneficial ownership information across the jurisdiction. We were talking about a register which is maintained in the corporate records of the company in the same way that there is also a register of directors, a register of officers, a register of members, a register of mortgages and charges. So this register we're talking about here is one of the internal corporate registers for the company, but that particular one will be available through this central access node to our local authorities to conduct the searches and reviews that I outlined earlier. Another aspect of that new part, Madam Speaker, is establishing beneficial ownership registers. This includes provisions that specify the duty of a company to establish and maintain a beneficial ownership register, the duties of corporate services or corporate service providers and the registrar, the required particulars to be held in a register, and the consequences of failure to disclose beneficial ownership. There's another section, Madam Speaker, which is comprised of that part, which relates to access to beneficial ownership information. These provisions specify the duty of the competent authority to establish a search platform and to execute a search for beneficial ownership information through that search platform. Another section, Madam Speaker, deals with enforcement, and those provisions specify offenses and corresponding relevant penalties. The last component of that part, Madam Speaker, deals with supplementary provisions, and these specify the exemption powers of the competent authority and the regulation-making powers conferred on the Cabinet. Now, Madam Speaker, my ministry conducted extensive public consultation, albeit in a relatively compact time frame, on the bill in December of last year. Some revisions were made, and the bill was officially published in the Gazette in early January. Subsequent to the public consultation, a working group comprised of industry members determined that several additional changes were necessary. Madam Speaker, several agencies in Her Majesty's government also provided feedback through the Foreign and Commonwealth Office. Of course, the agreement that we have with the UK, as is the case with all of our other overseas territory colleagues and the Crown dependencies, is what the UK is looking to ensure these provisions reflect the terms of. And of course, those have been published, so everyone should have easy access to that since April of last year. Those comments from the UK, Madam Speaker, were only very recently received. In fact, just a few weeks ago. So, Madam Speaker, between further review by the local industry representative body and committee that has been assisting government with these bills, this legislation, in order to effect the necessary platform in accordance with the exchange of notes, they have reviewed with government their comments and the comments from the UK in respect of this, and made suggestions and decided on appropriate amendments or changes to be made to the bill or the bills. Now, while the majority of changes that will be reflected in committee stage amendments, Madam Speaker, are for clarification purposes, there are three significant changes in approach that I should highlight. The first, Madam Speaker, is that several changes were determined as being necessary to simplify the approach to capturing beneficial ownership interest and information. One of the main comments raised in the public consultation was that there was perhaps an unnecessary degree of complexity in the bill in its attempt to reflect the approach to the UK's beneficial ownership register. The change proposed would require a company's register to record the ultimate beneficial owner rather than the first level intermediate owners, as is done in the UK approach. Secondly, Madam Speaker, the ability of local authorities to utilize a centralized platform has been improved, and this will certainly greatly facilitate international cooperation through the current legal arrangements. Finally, Madam Speaker, some changes have been proposed to allow for greater flexibility in the technological design of the centralized platform. So, Madam Speaker, that concludes my presentation in respect of this bill, and I hope that I have provided sufficient clarity as to the rationale, the need, and the construct of the bill and the design of the system which is proposed. And I therefore, Madam Speaker, am happy to commend the Companies Amendment Number 2 Bill 2016 to this Honourable House for passage.
Does any other member wish to speak? The Honourable Leader of the Opposition.
That's for style. Madam Speaker, I have long opposed the attempts to dismantle our confidentiality regime in the way that it has systematically been done over the years. Every time they come about reporting sessions with FATF and all sort of other abbreviations, every time it's done, it's chipped away at our financial services industry. So today, at this late stage, I rise to express great concerns about not only the direction that is happening with our financial services industry, but I think the speed with which it is being done. There is no doubt in my mind that none of this is accidental. I told them in December 2012, on the 7th day, it wouldn't happen under my regime, and they made sure of that. There's no doubt in my mind that none of this is accidental. It's a part of a preordained plan, the details of which London wanted to implement. They full well knew that had I stayed there, there's no possibility whatsoever that these provisions, what they say is creating full transparency on beneficial ownership, would have formulated in their current form. Not the slightest possibility. Madam Speaker, firstly, these provisions on beneficial ownership do not represent a global standard. They are nothing of the sort. They have not been adopted in the United States and will not be adopted in the United States. We wait, we'll see. Nor will they be adopted in most of the European Union states. Nor will they be agreed there. I think, leave aside the rest of the world for the moment. I think they would laugh at us for doing so. In the European Union, the European Data Protection Supervisor has ruled that access to beneficial ownership information of the sort now proposed here must be proportionate, and the legislation of this sort, Madam Speaker, creates a significant and unnecessary risk for the individual's rights to privacy and data protection. So no such analysis that I know about to proportionality has been undertaken here in the Cayman Islands, it seems. And if it were undertaken based on the history we have demonstrated, then clearly these proposals would be found to be not proportionate, nor would they be found to be of necessity. The courts of France have similarly rendered these provisions unconstitutional. They no doubt contravene the European Convention of Human Rights, and they contravene our own Constitution, both of which mandate a right to privacy in personal affairs. But you see, they tap it this way. It is for terrorists. Well, we know what happened about weapons of mass destruction. They weren't there. Terrorism is real, of course, and we should all be worried about it. But I don't agree that we won't continue as a reputable international business center unless we completely dismantle our confidentiality regime, and that is what is being done bit by bit by bit. If anyone thinks that good, legitimate, and credible business is not concerned, they will see when the impact is felt. Madam Speaker, in this day and age, we know that there exists a very real probability that registers can be hacked. They can try and say they put in good systems, but we know the possibilities are there, probabilities are there. The current state of available encryption is one step behind the skills of the hackers. And the criminals, the extortionists, the kidnappers, and blackmailers in their pay. No guarantees are provided by Westminster as to the outcomes when this highly sensitive information gets into the wrong hands, as it surely will. We have seen what has happened with hacking in Panama. We have seen what has happened in the British Virgin Islands, and we have seen what has happened in Washington, D.C. Secondly, no good reason exists for further extension of beneficial ownership registers, whatever kind. The Cayman Islands already complies, and in fact, I think leads the world with regard to proper and controlled information on beneficial ownership, which is available through numerous treaties and various other legal gateways to all law enforcement and most, if not all, relevant tax authorities, and with a right to due process under the law, with a right to due process under the law. There is no evidence that Cayman's current system for maintaining beneficial ownership does not meet the current Financial Action Task Force standards, which should represent the global benchmark. These provisions which modeled somewhat the UK provisions, may have been appropriate in the United Kingdom, where there were no prior systems for determining beneficial ownership, but they are entirely inappropriate in our Cayman Islands when the pre-existing conditions existed and which functioned perfectly satisfactorily. These new proposals also suspend the right of due process, which is fundamental to our legal system. What should due process under the law, or why should due process under the law now be suspended? And these proposals allow for fishing expeditions of the sorts that our courts have prevented for over 3 decades. Thirdly, Madam Speaker, the pre-existing previous procedures to which I am talking about have shown themselves to be highly effective in dealing with those very few, and I mean statistically insignificant, inquiries that come to us from law enforcement and tax authorities overseas. And it should be said with even less statistically significant consequences. Very few. So, apart from the noise, Madam Speaker, generated by very few extreme left-wing journalists, there is no proven rationale or concern that these new measures could address, but they introduce significant threats to the right to privacy and are already causing our financial services industry to lose business, and are disincentivizing, Madam Speaker, new business. Don't say it's not happening, it's happening. So the United Kingdom enforcing this legislation on us, and our government signing up to whatever request the FCO government have made, have not undertaken the basis analysis. There is no evidence of an actual problem which this legislation seeks to correct. None. You see, FCO will do that. And that is one of the reasons, Madam Speaker, when they were doing the FFR, when they told me we had to put that in, or you not get your budget. And I said, okay, we can put this in, but this clause got to be put in. If you, FCO, lead us wrong, and we suffer financially or reputationally, then you stand the cost, you pay. That was when they decided they want to lock me up. That's when they thought I had gone crazy to even suggest to them that they would have to stand responsible for their misdeeds. This is one of them. Somebody tell me, I know, I was there in the Treasury on that Thursday when the minister sat and said, you got to put this thing through. And I said, not this McKeever Bush. My pen, I threw it away. Go look for it. I ain't signing nothing unless other people sign it, and it's time for you all to understand that. Fourthly, Madam Speaker, all of what I have said is bad enough, but there is worse, and I think much, much worse to come. There are actually proposals in this legislation which fundamentally cut across our Cayman laws of property and ownership. Because if it's not in this one, the other ones, there are provisions which place restrictions on transfer of shares in Cayman Island companies, consequent on these beneficial ownership registry provisions. if and when it is understood in the global financial community that the Cayman Islands legislation on companies and partnerships and LLCs have provisions which restrict ownership on the direction of law enforcement or other persons, then the Cayman Islands financial services industry will be regarded as seriously disadvantaged and non-competitive. These are novel provisions which do not represent any global standard, which are, as far as I'm concerned, ill thought through, highly controversial, and which create highly negative implications for the ownership of shares or partnerships interests here in these islands. And in the light of those provisions, there is no good reason why international investors should continue to choose the Cayman Islands. And so, as far as I'm concerned, I say here, I believe with some certainty that these provisions pushed through by the government will, without doubt, have a highly negative effect on the Cayman Islands financial services industry and the revenue that it produces, on which the Cayman Islands people, our people, rely. It's happening already. Tell the truth. It's happening because of this change. Where? It's nonsense? Well, go ahead, call it nonsense. You show me where it's not, Minister. Huh? You show me where it's not. I know business that's leaving and going to Delaware and other places, of all places, going there. I'll show you how much they trust, but the United States not going to put it through, so they can go there, and that's why we're going to be disadvantaged. But I'm sure you will have your say when I sit down. And we've been good boys all day long, so we'll continue on that trend. Fifthly, the Cayman Islands financial services industry has been based from inception, from the days of Sir Vassal Johnson, on a legitimate right to privacy. No one can tell me that there have been any examples or cases where proper inquiries, and the legal person for the government is represented here. No one can tell me that where proper inquiries by legitimate law enforcement or even tax enforcement would not be met by existing legislation we have in place. Everything that we have that they need is here, except for this one more piece. They chop it away and put another nail in our coffin. This existing legislation, and let me say again, represents the leading global standards already and far, far exceeds the systems of transparency available in the United States, Central and South America, and indeed most of Europe, and as far as I'm concerned, the rest of the world. We have now, in addition to FATCA and the Common Reporting Standard, at least until such time President Trump, as I hope he will, defunds the OECD. I think it will be. And until such time as other jurisdictions in the world, and particularly the United States, catch up with these standards of transparency, we should not contemplate any further moves in that direction. The register of beneficial ownership has already created chaos in the United Kingdom, particularly in relation to the property market there. Its implications here in relation to the far more sensitive financial services industry, on which the finances of our people remain largely dependent, should not now be going in that direction. This legislation was a frolic of the now departed Cameron government in the United Kingdom, what proved to be a vain endeavor to increase its popularity with extreme left-wing groups. But, Madam Speaker, in one article that I want to read, and I'll take a copy of it and get it to you or lay it on the table. The Cayman Islands, it says in a news report recently, the Cayman Islands one of the world's best known tax havens, may soon give international authorities better access to information about companies that have long been shrouded in secrecy. Lawmakers in the Cayman Islands are expected to vote the next week on a trio of bills that would pave the way for law enforcement, especially in the United Kingdom, to rapidly learn more about some of the nearly 100,000 companies registered in the tiny island territory. The Cayman Islands, a UK territory long considered to be an offshore tax haven, has never previously maintained a centralized registry of ownership information. The creation of the registry, if approved, would be the result of pressure applied by the British government, according to Jason Sharman, a professor of international relations at the University of Cambridge in Britain. The Caymans and other British territories have kind of been arm-twisted, Sharman said. If the bills are approved, the registry is expected to be created by June 30th. It would allow authorities to obtain information within 24 hours of requesting it, according to a statement emailed to CBS News from the Cayman Islands Ministry of Financial Services. That's what they think of us. That's where they're going. It has no place. It has no place in the Cayman Islands, given the sophistication, Madam Speaker, of our financial services industry, and the transparency provisions that the Cayman Islands already have in place and will do, as far as I'm concerned, very great harm. The responsibility is on all of us here and the government. Madam Speaker, we are always in agreement to any request by competent law enforcement agencies international. We cooperate with them. That cannot be said, should not be an excuse. And it is worrisome, as I said earlier, that every time the so-called reporting time comes up, FATF asks for some change in our financial legislation, and it is always a chipping away of our financial services industry that makes us less competitive to the point where business is going to Delaware of all places. So, Madam Speaker, for these and many more reasons that I don't need to get into at this point on this bill, I do not support the bill.
Does any other member wish to speak? The fifth elected member from the District of Georgetown.
Thank you, Madam Speaker. Madam Speaker, it is what it is, and it's done. While it would have been helpful, Madam Speaker, if all the members of this House could have been given the same overview as the private sector by the government, especially if we're the ones voting on this. It is something that, as a country, I guess we were pressured to do. Madam Speaker, like the Minister of Financial Services said, there's no central register as pushed by the UK, but the system that's outlined in the FATF recommendations, i.e. the technology-based framework. Madam Speaker, maybe in his wrap-up, the Honourable Minister could say what the estimated costs for industry is for these types of upgrades, the IT tie-in, because I think that we have to be careful in the long run about escalating cost in terms of meeting some of these standards. Because I just want to share briefly a CBS Money Watch news piece dated 23rd of February 2017. But I want to just say something about it. Professor Sharman, the Cambridge professor, quoted or said that, and I quote, "Even if the Cayman Islands create a more streamlined registry, there's little evidence authorities will actually use it." He said there's no track record. And one question is, what information is there? If there is unreliable information, then it isn't very useful. Madam Speaker, I'm reading or watching this piece and reading the dialogue. What it highlights is that no matter what we do to prove to the world that we're on side, even though we were satisfied and we've been satisfied for a long time that our system is very robust and probably one of the most advanced in the world. But it's the world seems to have labeled us no matter what, and the bar will always be moving forward as soon as we jump over the next one. Madam Speaker, I will support this bill and the others that deal with the beneficial ownership scenario. But I just would like to caution us being the first and the guinea pigs at times, because no matter what we do, we're not going to be doing enough. Madam Speaker, I will wait for the minister to address the cost question that I asked, but otherwise I support the bill. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? Recognize second elected member from the District of Georgetown.
Thank you, Madam Speaker. No, I'll be brief because I know it's getting late, Friday evening. But I rise to just make a very short contribution in support of the bill that's before this House. Madam Speaker, I recall very vividly when the pressures from the United Kingdom for the Cayman Islands and other overseas territories was thrust upon us to engage in and to provide public access to our company information and ownership, beneficial ownership information in, I think it was probably 2013 or 2014. Madam Speaker, at that time, the proposals were pretty radical. It had to be a very public register, accessible not just to law enforcement, but to non-government organizations as well. Anyone who wanted that information ought to have access. But Madam Speaker, what has happened is that over time and through engagement of the government with the United Kingdom, it has allowed us to, I don't want to use the term water down, but to move away from the draconian and what, pardon? To move away from the draconian requests and demands that were being placed upon us. And what government chose to do at the time was to engage in discussion and negotiation with the UK government. And I think it's important for us all to understand that while there's provision here for us to engage into other agreements, that the only one who benefits from this in any way at this time is United Kingdom government law enforcement, and it is very restricted in terms of who can get after the request that information of the competent authority. And there are six entities that are entitled to request the information. In section 264.1, subsection 1, Madam Speaker, it lays it out quite there that the only ones that can make that request are the FIU of the Cayman Islands, the Financial Intelligence Unit, the Financial Reporting Authority of the Cayman Islands, the Monetary Authority, and the Department of International Tax Cooperation, the Financial Crime Unit of the RCIPS, and any other body which is assigned responsibility for monitoring compliance with money laundering regulations under or proceeds of crime law. So despite the challenges, despite the requests, despite the demands, no one still has, outside of this country, would still have direct access to beneficial ownership information. It is still a very narrow window in which anyone, and at this point, just the UK, that would be able to access or gain such information. So I believe while we are still under pressure, my personal view is that these pressures for the country are not going away anytime soon. And the only way that we can deal with them effectively is to face them head on and try to negotiate the most palatable outcome that we can for the country that seeks to not necessarily give everything that they want, but at least find a common ground where all can exist and that does not destroy the financial services industry that we all love and have come to appreciate for the place that it has taken on the world stage. Madam Speaker, I commend the Minister and I commend the staff of the Ministry of Financial Services, Commerce and Environment for the great efforts that they have gone to in negotiating with the UK to get us where we are and to get us to a point where we are able to bring this legislation and still, I'm convinced here that it will still preserve the privacy that people expect and that we are known for, and that there's only really very narrow opportunities for the release of beneficial ownership information. So, Madam Speaker, with those few words, I commend the bill as well and conclude my presentation.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call upon the Minister responsible for financial services should he wish to reply.
Thank you very much, Madam Speaker. Madam Speaker, in terms of the views of members that have spoken, that a cautious approach needs to be taken on issues like this. We don't have any disagreement. That is exactly the kind of approach that I take and my ministry takes on all issues that potentially have a negative impact, may have a negative impact on our jurisdiction and our economy. And yes, Madam Speaker, there have been initiatives, basically, sometimes one right after the other, in relation to transparency, particularly over the last 15 years, but it has really accelerated in the last 5 years or less. So there has been, for example, I think probably better than 10 years ago, an initiative to discuss or seeking to implement automatic exchange of tax information. That was stuck and going nowhere with little or no promise of agreement. But Madam Speaker, circumstances and events in the last 10 years have certainly served to inject an impetus, catalyst, whatever you want to call it, into these discussions, which have given them new legs because of the global financial crisis, because of other more recent issues as well. For example, the now infamous Panama Papers disclosure. These things we can't change, Madam Speaker. We live in and work in an environment where we're surrounded by lovely blue water, but a huge amount of our business, Madam Speaker, is international, well outside our borders, global in nature. And we are therefore subjected to the forces that exist in the global economy, and certainly also in regional economies where we have significant concentrations of sources of business for this jurisdiction. So, Madam Speaker, it makes no sense to say, well, we shouldn't do this or we shouldn't do that, we should resist it, we should tell them not to, we should tell them to go away. What is it? That's not going to get us anywhere. Madam Speaker, I well remember back in 2008, 2007, when there was a lot of, going into 2009, there was a lot of discussions about the OECD form of tax information exchange agreement. And Madam Speaker, the PPM government at the time who were handling that were trying in their negotiations with the OECD, trying to do what people in the business world in Cayman, the offshore financial services industry, suggested they should do, which was to negotiate, I'm getting there, which was to negotiate an agreement based on the OECD form, or their OECD template, which they had come up with at the time, but one also which gave a quid pro quo to the jurisdiction. And that means, Madam Speaker, the government at the time and the minister who was addressing these issues, Madam Speaker, was none other than our honourable current Premier, Mr. Alden McLaughlin. And he was trying to do the best for the country and trying to negotiate a tax information exchange agreement which gave us some benefits as well as agreed to share information in accordance with this tax information exchange agreement. Because, Madam Speaker, those things, transparency is a concept that in the context in which it exists in financial services today, it's based on reciprocity. But we don't have a direct tax system. So what are we going to get back in terms of information? It's all one way. To the extent that we're requested to provide information, we provide the information in accordance with the agreement. So rightly so at the time, the now Premier was trying to get some benefit in that agreement, whether it was the jurisdiction that we were signing these bilaterals with, or jurisdictions that we were signing these bilaterals with, whether it was just a promise from them to support the Cayman Islands, to stand up for the Cayman Islands, to say, yes, they've signed an agreement with us, and yes, they're good people for doing it, or whether it was something else, some trade-related issue, some other benefits. I don't know, I wasn't there at the time, but certainly they were exploring ways of getting this quid pro quo. And, Madam Speaker, at the time, the OECD came up with basically an arbitrary number of 12 tax information exchange agreements that should be in place. The government at the time and the minister responsible, I think in 2009, had got to about 6 or 8, maybe 9 of these agreements done, but certainly short of this magic number of 12, which who knows what it was supposed to relate to. Some magic dozen. And Madam Speaker, I raise that just to put it in context, because the leader of the opposition came out and said, that he would be very strong and he would prevent the UK from forcing anything on us, and he would not agree to anything because our system works and everything is fine. But, Madam Speaker, when he became Premier in 2009, the first thing he did was abandon the approach of trying to get some sort of quid pro quo, some sort of benefit for the Cayman Islands. And I'm not questioning whether that's the case or not. I'm making the point that I didn't see any strength there. I didn't see any chest thumping. And no, we're a clean jurisdiction, and we will provide you with information, but you're not going to force us to do anything. He ran off and spent a great deal of time outside the country for weeks at a time, and he says he was signing tax information exchange agreements to go beyond this magic number of 12. Now, I don't know if he was doing that, but certainly that's what he said, and we know that there were more than 12 agreements ultimately signed over the next 6 to 12 months. That, Madam Speaker, took the Cayman Islands off this grey list. So, Madam Speaker, we were on this grey list at the time because the government was trying to get some benefit for the country of this one-sided approach. And the leader of the opposition at the time came along and said, forget the benefits, let's just get this done. Well, if he had been in our position when the UK came along and said, you need to have a public central register, what would he have done? Would he have sat there and said no? Would he have ended up with the Cayman Islands on some sort of blacklist? No. His advisors would have told him, be smart about this and see what you can do to minimize the impacts, make your way through this minefield, and deliver the best outcome for the Cayman Islands. Whether he ultimately would do that, is speculation, but that's what his advisors would have told him to do, and that's what he would have been smart to listen to. Madam Speaker, where we are today, Madam Speaker, is that we have an agreement with the United Kingdom, which is the same in substance, same type of agreement that all other overseas territories has with the UK, and all crown dependencies have with the UK. And these agreements reflect effectively a current international standard of having, this is the FATF standard, of either having a central register or having a similarly effective system. Our approach is to say what we are doing and what we have been doing is a similarly effective system, and we're not going beyond that. The only thing we have agreed to do, Madam Speaker, is to put in place this centralized access platform in order to successfully share beneficial ownership information with the United Kingdom. This is all completely in line with current international standards. What the UK has done, Madam Speaker, and where they started off in their let's call them demands on us, was to have a central public register. We are not going to have either one. It's neither central, we are not aggregating data, and it is not public. But, Madam Speaker, it complies with international standards, and it allows us to address the underlying concerns expressed by the UK of wanting a system which could more rapidly respond to requests in relation to investigations of serious crime, fraud, and corruption. So, Madam Speaker, we are not doing something which goes beyond the good systems that we've had in place. All we are doing is changing the way we share the information. We access the information.
Honorable Minister, we've reached past hour 7. Could you give an indication how much longer you'd need, or you need to come back next week?
Madam Speaker, if you will give me 5 minutes maybe, I'm sure I'll be able to finish up then, and you can throw something at me if I go beyond that.
That's an invitation, a treat that I shan't fall into. Please proceed.
No delegation allowed. So, Madam Speaker, what I'm saying is that the Leader of the Opposition, we at a base level, I understand his concerns, but what he has described and the way he says he would approach it and the way he says we're approaching it is a complete misrepresentation. And Madam Speaker, there are other areas where he has misunderstood, or, well, let's just say he misunderstood. I wouldn't expect him to understand all these things, but For example, he referred to the EU data commissioner. He referred to the French court decisions, and he basically said that those decisions relate to what we are doing here in the context of the amendments proposed here and the proposed approach that we have, and they're at odds with it. But they're not. What those decisions, what the commissioner's decision relates to, what the French court decisions relate to, is the concept of a public register. And they're saying it's unconstitutional. They're saying it goes too far. They're saying it's an abrogation of a legitimate right of privacy or expectation of privacy. So anyone listening shouldn't come to the conclusion that those types of decisions and that information was somehow relevant to what we're doing. It's not. I said again, I've said before and I say it again, we do not have a central register. We do not have a public register proposal. Madam Speaker, the fifth elected member from Georgetown talked about perhaps having members of the House involved. I'm not sure that when these issues are fast moving, there's a lot of back and forth and discussion and negotiation. I'm not sure it's practical to take on board a suggestion like that. But I can give assurances that, as usual, we fully engaged with industry on these issues, Madam Speaker, and we certainly had a committee which was representative of basically a huge swath of the financial services industry, various disciplines, some of the very significant players who were engaged in this, both from Cayman Finance as well as the Cayman Islands Compliance Association, Madam Speaker, people who are engaged in the issues of compliance on a daily basis. And in fact, they're not just engaged in Cayman. Many of these people are responsible for the international operations of businesses that are set up in Cayman. So they're familiar with the regimes in many different jurisdictions. So, Madam Speaker, those industry members certainly, and their engagement, their involvement, certainly gave us a lot of confidence that we were clearly taking into account the real views of the industry and any concerns that may have existed. So, Madam Speaker, in terms of the cost which the member from the fifth elected member from Georgetown referred to, I don't have exact numbers to hand, but we think that the platform itself is going to cost somewhere in the region of $150,000 to $200,000. That's a sort of rough number. There will be ongoing costs as well, but in the context of whether we have a system that works, that satisfies the UK and is comparable to the same systems that exist in all of the other overseas territories and crown dependencies, we are going to get significant credit. It will give us significant credibility in their eyes and the eyes of the world on these issues of transparency, Madam Speaker. So, Madam Speaker, yes, we would not, in an ideal world, we would prefer not to have to chase after one initiative after another. And in fact, I was in Brussels recently participating in a think tank on the issue of corporate taxation, and that was one of the points I made, which was, there's one initiative after another, and there's no attempt to let it settle in, see what the benefits are, do a real cost-benefit analysis, and see how effective things are before someone else comes up with another idea. But that's the world we live in, and we have to, as long as we're adhering to international standards that are applied globally, that's the world we're going to have to continue to operate within in order to maintain our legitimacy, in order to maintain and protect our reputation as a strong quality jurisdiction. Madam Speaker, I know everyone is tired and it's a Friday evening, so I could go on for quite a while more, but I would thank you for the opportunity to close off in respect of this, and wish everyone a good weekend. Thank you, ma'am.
The question is that a bill shortly entitled the Companies Amendment Number 2 Bill 2016 be given a second reading. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Accordingly, the Companies Amendment Number 2 Bill 2016 has been given a second reading. I recognize the Honorable Premier.
Madam Speaker, before the adjournment, could I have a division, please?
Certainly, Madam Clerk, please call a division.
Honorable Alden McLaughlin.
Aye.
Honorable Moses Colonel.
Aye.
Honorable Kurt Tibbetts. Honorable Osmond Bodden. Honorable Wayne Panton.
Aye.
Honorable Marco Archer.
Aye.
Honorable Tara Rivers. Mr. Roy McTaggart.
Aye.
Mr. Joseph Hugh.
Aye.
Honorable McKeeva Bush. Mr. Barney Bush. Captain Eugene Ebanks. Mr. Alvis Saku.
Aye.
Mr. Winston Conley.
Aye.
Mr. Ezra Miller. Mr. Orden McLean. Mr. Honorable Anthony Eden.
The results of the division are as follows: 12 ayes, 5 absentees. The ayes have it. Accordingly, the second reading has been completed. Honorable Premier.
Madam Speaker, move the adjournment of this honorable House until Monday morning at 10 a.m.
The question is that this honorable House be adjourned until Monday morning at 10 a.m. All those in favor, please say aye. Against, no. The ayes have it. The House now stands adjourned until 10 a.m. on Monday morning.